SJC-13779 in the matter of an impounded case.
Okay, Attorney Cohen.
Good morning. May it please the court, Jennifer Cohen for the Commonwealth. The Commonwealth argues that consistent with the officer's community caretaking function, the exit order and pat frisk in this case were reasonable, and the motion to suppress should have been denied. I have asked the court to consider two findings of fact erroneous. I'm happy to go into those, but I do understand that we're not looking at the subjective intentions of the police, and we're looking at their whether they were objectively reasonable. So if there are questions on that, I'm happy to answer it, or I'm happy to move on to.
Can I just ask about the pat frisk before putting the juvenile in the car? Does it matter? It seems like there was some argument made that, there was safety issues. Is that your argument, or do you have a different argument?
My argument is that both the exit order and the pat frisk were reasonable under the community caretaking exception or function.
Okay. And so if we were to disagree that you can just pat frisk someone under your community caretaking responsibilities as a police officer, where does that leave you?
So, of course, my first request would that be, if there is a valid act of community caretaking, an officer be able to frisk before placing someone in a cruiser. However, if the court's not inclined,
basis of that. So, if it's not because you think if it's not because the officer thinks that the juvenile may cause pose a risk, what's the community caretaking part of that?
So I think asking for discretion for officers to be able to do this is based in the fact that placing somebody unrestrained in the back of a cruiser could pose a danger to officers, just as a blanket. I think obviously when you're operating under the community caretaking function, you're not acting in an investigatory capacity. So this reasonable suspicion of being armed and dangerous, I don't think would be appropriate, because there may be situations where someone is engaging in community caretaking. There's, the concerns that they might have could be related to the safety of the individual as well as their own safety. So there could be a concern for self-harm potentially if someone is experiencing a mental health episode.
And they don't have to have any reason to believe this. This is just as a matter of course. I'm going to pat frisk. I'm not going to.
I think there's two ways to look at it. That placing someone in the cruiser unrestrained in any circumstance will pose a threat to the officers. And I think, there is an argument for that should be enough to allow an officer to make the frisk. They shouldn't be asked to either be concerned for their own safety or disregard their own safety, or, not engage in this really important community caretaking function. The other way of looking at it is, and I would ask the court, if you're not inclined to find a blanket rule, that there should be some kind of objective safety concerns or objectively reasonable safety concerns for the officer or for the individual. So I suppose that goes to the other part of my argument that, some of these safety concerns might not rise to the level of reasonable suspicion of being armed and dangerous, but they nonetheless cause concern for the officer or the individual involved.
You have ducking here, right?
Yes.
And you have the fact that he's associated with a known gang member, right? Does that give you enough to say we don't adopt the blanket rule, you can pat frisk every kid you put in the back of a car?
So
we have two facts that suggest there may be a potential danger here, right?
I think as a finding of fact, the judge did say that the two backseat individuals were moving excessively, looking back at the cruiser repeatedly and ducking. The other individual wasn't.
Sorry, can I interrupt you? It's important. She's reciting the testimony at that point. She says, the officer testified, ... The officer claimed. And then in her findings later, she expressly finds, I find that the backseat passengers looked behind them when they were stopped. So to me, that seems like a tacitly, she did not credit the testimony about ducking. Do you agree with that?
I disagree, Your Honor, because at the start of her findings of fact, I think they're at record appendix, page 92. The judge states the following facts are derived from the credible evidence and reasonable inferences adduced at the evidentiary hearing on this motion.
Well, she's saying that this is the stuff I found credible.
Yes, and part of what I think, I agree, it's posed as this was the testimony, but there's no explicit credibility finding at that point. The only point that the judge discredits anything is when she's talking about this social media firearm tip.
No, she also implicitly discredits the officers when she says, I find that they were not acting in their community caretaking function. They were viewing this as a traffic stop, and they were not frisking him in a community caretaking function. I realize that you're arguing that's a question of law, and I agree with you, but I think that it is a discrediting to some extent of the officer's testimony.
I agree that I think it can be read as that. I also believe
But isn't
that
the ducking, just to follow up on Justice Stewart's question, the ducking in the facts section, she describes the testimony. And then in the conclusions of law, she ignores it. But she doesn't make any fact finding rejecting ducking. She just sort of skips over it when she starts doing her legal analysis.
Well,
right?
I would agree with Your Honor, and I would say that to me, this comes across more as the judge not giving a lot of weight to that part of the testimony rather than discrediting it entirely.
Can I ask you one question, a threshold question about the Pat Frisk? Is the 39H argument waived?
I would argue that it is, Your Honor, yes.
Okay.
It wasn't raised in the juvenile's motion to suppress. I don't think that it was adequately raised in any of the argument. The Commonwealth wasn't advised that this would have been an argument, and so didn't present any evidence on that point.
Okay, just wanted to get your point. Thank you.
The defense counsel did argue that the juvenile was not subject to a court order below.
Yes, but it's not clear what that means. And I think where, we're now talking about this very specific CRA legislation, that if that was the intention, that there should have been a mention of those statutes.
I mean, there's obviously no factual record for us to consider whether this statute applied to this particular child, et cetera. But do we not, if we're presented with a constitutional question about how juveniles can be treated pursuant to the community caretaking function and what is reasonable in that context, should we not consider a law that has been passed by the legislature that specifically governs what police can do when they encounter a child who has repeatedly run away?
It's not entirely clear to me from my reading of the first section of the legislation that the intention was to govern this kind of situation. I do understand that the police policy contemplates the an officer advising a parent to seek this order, but also in the policy, there's nothing that says, police, unless there is a CRA order, you are not allowed to do XYZ. I think the policy treats all missing juveniles the same across the board. Maybe that's incorrect, but I would say from what I read of the statutes, I'm not sure that is applicable here in any event.
But my question was a little bit different. The CRA statute applies to children who meet the level of being adjudicated a child requiring assistance. These are children who have needs of assistance and specifically not just have run away one time, but have run away multiple times. And in that context, the legislature has provided that those children shall be, first you call their guardian or parent or DCF if they are in DCF custody. And then secondly, failing that, you bring them to the nearest shelter without first bringing them to a police station. And then thirdly, you, worst case, bring them back to court. Now, again, we don't have, because this wasn't litigated below, we don't have evidence whether this statute strictly applied to this child. But I go back to my question, should we not take into account not that it necessarily sets a constitutional standard, of course not, but when we're considering what's reasonable in the community caretaking function, should we not take account of a statute that we can take judicial notice of, regardless of whether it was litigated below?
Of course, your honors can do that. I guess my point is that I understand what you're saying, that there is guidance on this point here, but I would just note that these statutes appear to be pertain to getting services for children and families and for custody arrangements, and apply to, as Your Honor said, habitual runaways, habitual truants, that sort of thing. And I think, the point is to get the juveniles or the families into the court system to be able to get the services. That isn't necessarily what we're dealing with here. I understand.
The first line is give the child back to their guardian.
Correct.
And here what occurred was the child was taken out of the car, zero conversation, immediately pat frisked. So it's really far afield. Zero, and the officer testified, it was my training that all juveniles who are found should just be taken straight back to the police station, which seems like it.
I think he did testify that he was trained to believe that they're flight risk and they should be brought back to the station where the guardian could be called. I understand Your Honor's point, but I do think that in the circumstances, objectively, while it might have been better to have more conversation before taking the acts that he did, I don't know that that necessarily changes the landscape of what is objectively reasonable. It is a December day. We're in an area that the judge found to be high crime. This officer testified that he'd responded to multiple shootings in the area. He's been missing for a long time, and I think that is important. And I think the fact that perhaps he doesn't want to be returned to his placement isn't necessarily helpful to his case, because that might make him more of a flight risk. And I think this child deserved to be found. And I don't think that it was unreasonable for them to act as they did here.
What would be the outer parameter of permissible police conduct under the community caretaking function, where the caretaking is simply that there's a runaway child?
I'm not sure if this is what Your Honor is asking, but I did.
I'm just, the caretaking exception is normally either caretaking of that individual that they're responding to, or the safety of the community around them in some kind of emergency way. At least that's the way I think of it, right? And correct me if you have some other understanding of it. This doesn't fit quite squarely into that mold. There's suggestions, maybe, potentially, that the child could be at risk, one, because they've run away, and two, because it doesn't look necessarily that they're in the custody of, let's say, responsible people. And does that alone allow, an unlimited number of police decisions or types of police decisions? What would be the limits of what the police could do?
I'm not sure I can say what the limit would be, but I would say the closer question here is the pat frisk. I understand that. I think the exit order, where this officer immediately recognized the juvenile to be missing, he's a teenager. I think it's unreasonable to believe that you could leave the juvenile in the car and ask questions and get honest answers if he is actually in trouble. I think without a doubt, if a missing juvenile is found in a vehicle that could drive off at any moment, there's no question that individual should be taken out of the car.
From the car.
The pat frisk, perhaps the court decides that the appropriate action would have been to, instead of just confirm with his fellow officer, to call the station and make further inquiries about the status of the juvenile. I think it's also should be taken into consideration that, this juvenile was in the custody of DCF. Would the officer have been able to get in touch with his caseworker or his placement officer immediately if he tried to call on the side of the road? I think it makes more sense here to transport the juvenile back to the station where he'll be safe, where the officers have time to contact the appropriate people. I can't say where the line would.
So it seems to me age might be a factor in that. If the missing child had been 8, maybe.
Well, we did
looks very different.
bandy about different hypothetical situations. What if this was a 12-year-old in pigtails?
So why wouldn't we, in the mix of those considerations, have to take into account what the legislature has provided in 39H?
Again, I would say I understand that there is guidance here in this particular situation, but it's not entirely clear to me that it's applicable to this situation. I do understand that there is guidance, but again, I don't know if it was meant to inform this kind of a situation.
Chief, can I ask one more question? So in the context of exit orders and traffic stops, we have under the federal case law, as I understand it, drivers and passengers can be exited during a traffic stop for the safety of the officers. We've rejected that under our Constitution and said that instead there has to be a reasonable suspicion of, a crime afoot or safety issues, and then to pat frisk that they're armed and dangerous. And we've stuck with that despite the federal case law to the contrary. Why would we adopt for pat frisking a missing child a blanket allowance when we've rejected it for traffic stops as the rationale of officer safety? We've recognized there's officer safety concerns, but we've said, officers make judgments all the time, and they can judge whether this particular individual poses a safety risk. And if they do, then go ahead, pat frisk them. Why couldn't we adopt that as a rule under our Constitution, given that we've rejected the federal jurisprudence?
I think we're dealing again with a different situation where I think I understand Your Honor's point.
No, but the same rationale you're giving here, officer safety and transporting a child, they don't know if the child's armed, so just go ahead and pat frisk any and all of them for no reason, all reasons, whatever. That's the federal exit order for a traffic stop, and we've said no, we trust officers can make judgments.
In that context, you're having somebody exit a car and stand outside the car, correct? And you're pat frisking them. You're not putting them in the cruiser at that point. You're just checking for weapons for officer safety during the duration of the stop. It's a different, I think it is an investigation at that point. So I think it's different because of that. And I think it's different. No, I guess
I understand that there's a difference. My question was more about our rejection of a blanket rule for officer safety reasons in that context, and why we would be adopting an officer safety-based rules for missing children, right? Given that we've rejected it for traffic stops. And I ask that because a lot of the out-of-state jurisdictions that the appeals court relied on also adopt the federal jurisprudence in exit stops, in exit orders during traffic stops. And so it seems to me that they go hand in hand. Either you do it on exit orders or you don't.
I think that when you're operating under the community caretaking function, you have different considerations. And I understand this case is about juveniles, but I think the greater question is if you need to transport anybody pursuant to a valid act of community caretaking and you need to transport them somewhere, can you pat frisk anyone? And I think...
Wouldn't that just go to the reasonableness of the constitutional inquiry? So if there's no safety concerns, probably not reasonable to search, but if there is a safety concern,
so I think...
If it's an 8-year-old versus
so there's the
17-year-old.
My first ask would be for that, you have the safeguards of requiring the officer to be operating under the community caretaking function before they can pat frisk. But additionally, if your honors are not inclined to make a blanket rule where you're able to do that, then the second safeguard would be the objectively reasonable safety concerns for the officer's safety or the safety of the individual. And I just think that the reasonable suspicion considerations, I think some of the same considerations go to the standard that I'm proposing, but I think that is a higher standard for a reason, and I think it's because the officers are acting in a different capacity in the sort of stop that Your Honor's talking about.
But you realize that, I mean, it's an intrusive event. So, I mean, shouldn't juveniles also get the same protections that others get as, suspects of crimes?
When we're dealing with the community caretaking function, I think, and I don't want to misstate it, but officers are allowed to take reasonable steps that are consistent with the purpose of this community caretaking function, even if those steps include constitutionally intrusive actions. Thank you.
Attorney Toomey.
Good morning. May it please the court, Dennis Toomey on behalf of the juvenile. Police putting their hands on vulnerable children, police using force to take a juvenile teenager into custody like a criminal. That's supposed to be the last.
What is an officer supposed to do? There's a missing child alert. He just got it that morning. There's the child. You think it's unreasonable for the officer to exit the child and say, this is the missing child. I have found him.
I think it was unreasonable here, not necessarily in all cases, but as to what the officer should have done. The first step needed to be to ascertain the juvenile's identity and his relationship to the adults in the front seat.
But we know that they're not the people who reported him missing.
No, we don't.
Oh, we don't know that.
No, this officer.
So
never
we think
asked.
you think it was undisputed or questionable whether any of the other adults were the guardians who had reported him missing.
Yes, that's a big part of my argument, is that police had no probable cause.
And given that he was sitting next to the gang member, you thought it would be a good idea to question, or necessary, I guess, constitutionally, for the officer to question the other three adults in the car.
I think the first question needed to be, what was the relationship between the adults in the front seat, who could have been his foster parent and DCF social worker? Because I think we can all agree it would be unreasonable if.
What if they weren't? What if they weren't? What if they had abducted him? And instead, and so the officer is then required to say, hey, is that your guardian? And they, the driver, who's otherwise pleasant, takes off. What is the officer, what is the consequences, do you think? What kind of legal regime would that set up? Where a parent reports their child missing and the child is found by an officer, and the expectation is that our Constitution requires that the officer not exit that child and instead ask the adult or ask the child, what's your relationship? Are you the parent that reported the child missing? And then it's not, because he's been abducted, and they take off.
Well, I think the analysis is different if we're talking about an abduction. We have the Amber Alert statute and other authorities that would change the analysis here.
But what if, he doesn't get to decide, right? He's a juvenile, he's a minor, right? He doesn't get to decide, I don't want to be home, right? That's the whole point.
Well, running away from home one time, it's not a crime or a status offense.
Oh, absolutely not a crime. I'm just wondering, I'm wondering about the legal rule that you want us to set up that requires officers who have found a child who's been reported missing. You want the officer to have to ask the other adults in the mobile vehicle whether they're related, responsible for that child.
I think that would be part of a well-being check. If any community caretaking exception exists, it's supposed to be a non-coercive well-being inquiry at first. And here, it's not just that they didn't ask questions. They're also relying on a stale 6-month-old tip that they didn't corroborate contemporaneously. So they don't know if he's still a runaway on the date of the stop.
The officer does, because he got it at roll call that morning.
He saw a bulletin at roll call.
But hold on. But he got a bolo that morning before he started his shift that this child was still missing. So it's not a 6-month stale to that officer. That's in that officer's head. But when you started your argument, you said that the yanked out of the car, that's not any of the findings that the trial judge made. The trial judge said he issued an exit order and the child cooperated and got out, and then subjected the child to a pat frisk. There wasn't any of this other overlay of the drama of what you started out your argument in the record of what the trial judge found. So back to Justice Wendland's point. You're also infusing the same question I'm going to ask, I asked of the Commonwealth. You're infusing the analysis into the statutory stuff that you're supposed to do under 39H, okay? But again, separate that for a minute. You've got an officer that goes out and roll call, gets a bolo that this child's still missing. Earlier in the day, sees this vehicle and sees this person that he knows to be gang involved. I understand the judge doesn't credit the issue about what was communicated from the detective, but independently, this officer knows that that person in that car this morning is gang involved. Sees the same car later on. That person is in the car, in the back seat with the juvenile. And it's December, and again, we're talking about what's reasonable under the caretaking function. I'm just wondering, what is it that you propose the government is supposed to show us that the officer can do in that circumstance? You list off all of these things that are embodied in 39H, but I'm talking about in real time. What is the officer supposed to do other than say, this child's missing, here he is, and I'm going to at least make sure that child is going to be safe by keeping that child with me? The first part of that.
My position is that police cannot take a juvenile into custody, which is what the officer admittedly did here, take a juvenile into custody, unless there is emergency under the emergency aid exception or authority under 39H. 39H grants protections to juveniles so that they are not taken into police custody unless
That's
certain
only
requirements are met.
juveniles are subject to a CRA, correct?
That is correct, Your Honor. That's one of the prerequisites to take them. But our argument is that it creates protections the same way the intoxicated adult statute creates protections. So that this officer should not have been taking the juvenile into custody unless there was a CRA petition or an emergency. And here the motion judge found there was not an emergency.
Why we make an emergency for warrant exceptions because of automobiles and how they can just take off. Well, now you've got a juvenile who is, at least to that officer, known to still be missing in the backseat, back to Justice Wendland's point, in the backseat of a moving car. Why is that not an emergency?
With a gang member.
With a gang member. Why is that not an emergency?
First of all, I must push back on the gang member reference. The testimony was that the passenger male in the backseat was an associate of a gang, but there was no testimony as to what that meant. But there was also no testimony that that person was ever violent, ever armed, ever committed any crimes.
I'm confused though. When you find a missing child, I understand your custody point, but when a police officer discovers a missing child from a roll call that day, so it's fresh, he can't remove the child from a car with a gang member? Forget about custody. He can't take that child out of that car?
I think in different facts, the officer could have given an exit order to better assess whether the juvenile was in danger, to ask questions, which is the purpose of community caretaking. But that did not happen here. The officer admitted he gave the exit order just to go to custody. So I think this case is distinguishable.
Well, and here's the factual findings. Officer Fabian had previously had numerous encounters with Ricky Montilla and identified him as an associate of the Trinitarius, I guess, street gang. Okay, that's a specific finding by the judge of the person that was sitting next to the juvenile in the backseat.
Yes, my argument is that that did not create an emergency to take this juvenile into custody, especially when there was no inquiry of the adults in the front seat. And the bolo that you referenced, there was no testimony as to how that was created, the veracity or basis of knowledge, which is a requirement. Police cannot just act on a bolo or broadcast unless they introduce evidence as to the source of that. So here we don't know if police ever called anyone in December and said, hey, is this juvenile still missing? Or if they just reprinted and reran the same bolo every day for 6 months.
Are you using search and seizure law now?
I do believe I am for the bolo, yes, Your Honor. But the 39H statute requires probable cause that the juvenile is currently a runaway.
Did you argue 39H below?
Specifically.
I did not. I was not the trial attorney. The trial attorney did
No,
not
I mean,
reference.
when I say you, I'm talking about, was the argument made?
The trial attorney did not specifically reference the CRA statute or 39H, the child custody statute. She did, though, argue that there was no court order.
So that there was no court order.
That's correct. And she argued that the pat, frisk, and exit order were unreasonable and that no exceptions applied. At that point, the burden shifted to the Commonwealth to introduce whatever evidence they needed to justify it. And
Let's
they knew
just
enough.
say we disagree with you that the legal regime should be that if you see a child in a car next to a gang member and the child has been reported missing that morning, that the officers reasonably could, under their community caretaking function, exit the child. Can you talk about the pat frisk? What is your position on that?
My position is that the pat, frisk here was unreasonable because it was done just for custody, but also that there's no good reason why juveniles in this situation should have less rights than suspected criminal adults, intoxicated juveniles.
So are you saying categorically the police can't pat frisk someone under the community caretaking position when they have them in the cruiser?
Yes, my position is that the armed and dangerous standard should apply.
All right. So if there was, well, that's a different issue. So if that goes to reasonableness. If they had a person who was in a mental health crisis, who was reported to have suicidal ideation and was clearly distraught, the police officer is going to, under community caretaking, take this person into custody and bring them to the police station. Are you saying that they can't pat frisk the person suicidal and in a mental health crisis before putting them in the back of a cruiser?
No, I'm simply saying that in this case.
No, answer the question I just asked you. So can they pat frisk that person?
My position is that the armed and dangerous pat frisk standard should apply unless statutory authority says otherwise. So my answer is no. If there was no reason to believe that person had any weapons on them, then the fact that they were suicidal.
The question is trying to find whether there's a weapon. So that's the point, of whether they're going to harm themselves or others. So in the spectrum of that, doesn't this all go to reasonableness? So if the runaway was 12 years old, if the runaway was 17 years old and with gang members, or if the person was in mental health crisis or just simply intoxicated, aren't these all factors the police can weigh as to whether or not it'd be reasonable to search, given that they pose a danger?
Yes, I agree that all those factors should be considered by the police.
Okay.
My position just, though, is there's no good reason why the armed and dangerous standard should not apply to juveniles. And even if there was a lesser standard, like the intoxication statute, which says police need a reasonable belief that there's weapons present, which the legislator specifically put in to that statute, which governs juveniles that are incapacitated. And the legislature specifically chose not to put that language into 39H, governing custody of runaways, which suggests a legislative intent to not treat juveniles like criminals, not pat frisk them, not handcuff them, not bring them to the police station, which is what the officer was trying to do here, supposedly, if this had been true caretaking and not a pretextual investigation. But the other piece of this is...
What if the officer was going to take him, to the local coffee shop? That would have been okay?
No.
Okay.
No. Under 39H...
It doesn't matter that he was going to take him to the police station.
Well, it only matters that he's prohibited from taking him to the police station. So since that was the justification, it was unreasonable. The officer is supposed to take the juvenile in order to his guardian or to DCF or to a shelter or to juvenile court. They can never take runaways to a coffee shop or to the police station. And that's a statutory protection that the legislature has afforded.
But that's also presuming that we are with you on this 39H overlay. But if we're not, if we say that argument was waived, even if it's part of our analysis here, I could understand if there was nothing else that the officer was doing other than ensuring that somebody came to take responsibility for this child without going anywhere with the child. But the child is going back to the police station. So the second part to Justice Gaziano's question that I'm intrigued about is, you're taking somebody into your police vehicle and you've got your back to them in the cage. And the police officer is just expected to put anybody back there without making sure that that person can't harm the police officer or themselves. That's the rule you want us to come out with.
No, I'm simply saying that there should not be the blanket rule in the opposite direction, which the Commonwealth suggests, that there should be no rights at all. I think.
But what is your rule?
My rule is, first of all, that the armed and dangerous constitutional pat frisk standard should apply. But even if you disagree, police still must show some evidence of safety concern. And here, the judge found that they did not. And to Justice Kafter's question, although the judge's findings were a little bit confusing, that she put her credibility determinations in the conclusion section, she did say The juvenile did not make any further movements other than looking back at the cruiser.
Hey, keep reading the sentence. At the time, she doesn't, it later, isn't that sentence, if you read the full sentence, dealing with later, once it's not the initial ducking,
Well,
right?
with respect, the full sentence is, the juvenile did not make any further movements other than looking back at the cruiser behind him when the stop originated. And so when the stop originated is when the supposed ducking occurred. So if that occurred at all, which the motion judge didn't find, that was not the juvenile. If it was the...
I just found her fact finding
Well,
is not great on this. Yeah.
well, what do we do then, and how do you grapple with our jurisprudence, including Justice Welland's opinion about when you're in the community caretaking realm, that there's certain things that may not necessarily fit under some of our constitutional jurisprudence that the police get to do. And if that is to mean anything, why doesn't it mean that if we're going to put you in the backseat of our cruiser to take you someplace, that we make sure that you don't have any weapons on you?
If any freestanding community caretaking exception exists and police are allowed to do more than a well-being check, I just believe that they should not be able to go so far afield as to automatic immediate custody. And I believe that any sort of search of the juvenile in this specific case was unreasonable because of the facts and the motion judge's findings. This was a disproportionate response to a potential runaway. I can see that I'm out of time. Are there any further questions?
We're all set.
Rest of my brief. Thank you.